and I will not dare to give advice on Colorado law, in part because Colorado gun law is weird and highly specific, and in part because once I start doing that, I'm practicing law illegally outside of the state in which I am barred, and I could get in very big trouble.
We are the Armed Attorneys. Today we are doing a bunch of your questions answered. These are things that we farm from our comment section. It's our favorite segments to do, talking about peaceful protesters, some sign law questions, and how does New York State Rifle and Pistol Association v. Bruen interact with the big, beautiful bill. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is sponsored by Aura.
It's scary how easy it is for someone to Google your name and find out your private information, your home address, phone number, email, and more. It's not just inconvenient, it's dangerous.
It happens because of data brokers. They collect your data from all over, like public records, data breaches, and sell it to anyone who wants it. Marketers, scammers, even stalkers. And they do it without your consent, making billions in the process. We know it's a big threat, but unfortunately, it's completely legal. And even if these companies are required to take down the information, good luck not getting buried in the process.
Or you can do what we do. Use Aura, the sponsor of today's video. Aura does so much more than just removing your name from Google searches. They take care of the hard part by automatically removing your info from these sites and keeping it off. Aura also alerts me if they find my phone number, email, or social security number on the dark web. They'll let me know fast if anyone tries to use my information to access my credit or bank accounts. And if the worst happens, Aura provides up to $5 million in identity theft insurance to help cover the damage.
Plus, Aura provides all-in-one digital security. Aura includes a world-class VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and malware protection, all inside one app. Aura helps protect your identity, your money, and your peace of mind. Let Aura do the hard work of keeping you safe online. Go to aura.com/armedattorneys to try 14 days free. That's enough time for Aura to start scrubbing your personal information from these data broker sites automatically.
All right, we're going to kick this off with a question to Richard.
All right.
This is at David Hudman, 7144. Question: with the peaceful protesters,
Yep.
throwing big rocks in Texas, is that considered a deadly weapon? They can cause death or great bodily harm. Would this either thrown at you or at your car be considered okay to use deadly force? Unfortunately, there are more and more peaceful protests. So, I think we can talk about probably nationwide and Texas, huh?
Yeah, so first things first, is a rock a deadly weapon? These definitions are going to vary, but I think we're going to see some commonality. Is it manifestly designed and intended to cause serious bodily injury or death? No. Okay, well, maybe it doesn't meet that part of the definition. But in the manner of its use, is it capable of causing serious bodily injury or death? And this is looking at this specific item in this particular context. And the answer for that is, yeah. I've seen people throwing rocks off of interstate passovers. I've seen just cars driving by, people throwing things. And so,
well, it depends on the size of the rock.
Right.
If you're throwing like a little, like a skipping rock,
sure.
No, but
we've seen all, yeah. But so here's where you get the lawyer answer of, it's going to depend. So, all right, deadly weapon. Is it going to be considered a use of deadly force? Well, anytime you're using a deadly weapon against a person, yeah, potentially deadly force would be justified so long as it's reasonable, immediately necessary. Now, I think it's going to be treated a little bit differently than, let's say, somebody shoots a firearm at you. Well, guess what? We know after one round is discharged, guess what's in the barrel? Another round. So a rock may be a little bit different, and it might undermine necessity just because if the person doesn't have the capacity to throw rocks rapidly or something like that. But it's going to depend.
Yeah, and I would say, you need to, immediacy is going to be your best friend or your worst enemy in this kind of situation. So, they are actively throwing the deadly weapons. Yes. Pile of deadly weapon rocks behind them. Probably not. You're gonna have all sorts of factors here, but immediate necessity when it's gun versus rock is probably gonna be your best friend. What do you think?
Yeah, probably. If it's happening right in the moment, just be careful. And here's what, anytime there's a defensive incident in a car, this is kind of what I go to is police, prosecutors, maybe even juries.
Yeah.
They say you're in your big, safe, metal, movable box. Why didn't you keep driving? Even in states where there's no legal duty imposed on you to retreat before using any level of force, you're in a place you're legally allowed to be, you're not committing a crime, you didn't kind of, provoke the interaction. Guess what? A jury might get instructed on that, but juries just have the hardest time wrangling with folks using deadly force in a vehicle.
Yeah, they do.
So, all right, here's the next one for you. This is PCYR 9999. This is Texas specific, but I think it's worth talking about. So Texas Penal Code 30-6 has a promptly left defense to prosecution, but it only applies if you actually promptly leave. What happens if an officer is the one who gives you oral notice and they tell you that you're detained and not free to leave? You're stuck inside the premises, but you also need to leave to be able to argue this affirmative defense. How does that work?
Yes. So I will say, apparently we really like your questions because we've answered you on this, on a different matter before. So yes, there is, right? So we're talking about signage law. We're talking about you post your signs up there. And in Texas, those signs really are pretty much legally insufficient against LTC holders until and unless, we're talking about 30-6, 30-7, you are given oral notice to depart. And that's an exception that or defense to prosecution, actually, we worked into the law in, I think, 2019. But you are absolutely right. It says that your defense to prosecution is if you do, in fact, promptly depart after being given oral notice to do so. But the law doesn't say you have to be given the opportunity. And I think our airport law actually does say you have to be provided such opportunity.
Yeah.
And this does not.
Well, that's one of those situations where it's like if the legislature wanted them to require that they give you an opportunity to leave, I think they would have put that in there because we have that in a different place in our law. I mean, obviously they're aware of this mechanism and they haven't provided for it.
See, I think this was negligence.
Well,
this was before.
No. I'm talking about
what
the courts are going to do.
Oh, yes.
The courts are going to look at the words and say, what did the words say? And
yes.
The legislature left this out. So that must have been intentional.
Yes, I don't disagree with that. However,
no, I know how it's negotiated. No, exactly.
You and I know exactly how this happened.
No,
and it was just stupidity. But here's the thing, though. I agree, and I think a prosecutor is for sure going to make that argument. I don't think a jury's going to like it. If you are an LTC holder, you get your notice from police, and you're like, okay, man, I'm so sorry. I didn't know. I didn't see the sign. I'm out. And they're like, hell no, you're not. Like, that, no.
Well, and I'll say,
no, they're not going to like
that. And while this is Texas specific, I bet there's other states that have if you leave, you have an affirmative defense. So this probably applies elsewhere. But I'll tell you, most cops don't want to do the paperwork. No. If they can say, hey, man, get out of here, the person leaves.
Yes.
They don't have to write up any report. In my experience,
if you've ever watched a body cam channel,
yes,
like they give you,
they're going to give you multiple opportunities.
Come on, please just go. Please don't make me do this.
But our experience. I mean, we talk to a lot of people every single year. I haven't seen a cop say, "Aha, we got you." No. As laid out here, it seems like they always give you an opportunity to leave.
Yeah, we actually don't see 30-6, 30-7 prosecutions in Texas. In fact, how long have I been doing this?
A long time.
A long time. What, 12 years? No, 11 years here. For 13 maybe as a lawyer. I have never seen anyone prosecuted under the 30-6, 30-7 law. Ever. It doesn't mean that it has never happened in the state of Texas. I've heard tale of maybe once or twice, but no, people don't get prosecuted for this. So that's good news.
Yeah.
All right. So we have at SpudboyQ our next question. I have a question. By the way, thank you for putting words like question into these. It really does help us find when someone has a question. My local convenience store has the proper signage for non-carry, but the manager told me to ignore it. Does that nullify the sign as far as the courts are concerned if the unthinkable happened and I was forced to use a firearm within the store? And then we've got a response at To Truth for Liberty who says more recent communication, verbal or written, should supersede that sign as long as they have apparent authority and no one with more apparent authority has superseded them, which is probably true some places, but let's talk about it.
Yeah, so kind of a couple of things going on. All right, and we're talking about no gun signs. And what these are different than statutorily prohibited places you might find in your law. Property owners, they have the right to let people on their property, exclude people from their property. And when we talk about no gun signs in private locations, really we're talking about trespass law, which is entry into a place knowing entry is forbidden or remaining in a place after being told to depart. And so all this hinges on private property rights. And so if you are an employee of a store that has posted these signs, the issue becomes, hey, are you on notice that entry with a firearm or remaining in a firearm in this place is prohibited? And I'll say, typically you need the cooperation of these private businesses to, effectuate a prosecution. And so if your employer says it's good, you're probably going to be okay. But here's something I want people to be on the lookout for. These kind of written permissions, or, hey, this sign doesn't apply to you, or, we think it's okay for you to have a firearm. That's all probably good evidence that, you didn't enter into a place knowing entry is forbidden. But guess what? In some laws, and you need to look for this, the statute needs to provide specifically for written permission, and we don't have that in Texas.
Yes. So I would say this is Two Truth for Liberty's advice is probably the best advice in most of the country.
Yeah.
Because you've just got your sign, which is just your general sort of trespass, and, someone who runs the business says, don't worry about it. You're okay. I think that's probably good advice in most places. It is not in Texas. So, Spud Boy Q, if you are in Texas, there actually is no written permission exception to 30-6 and 30-7. You're just going to have to hope that whoever really is in charge of, hey, this is the person whose name's going to appear on, as the complainant on your criminal trespass, that they agree with whatever management told you not to carry in. Because if they don't, there's nothing in the law that says you are actually accepted.
But I'll say it's good evidence that you weren't entering into a place knowing entry is forbidden. So it's evidence of that.
It is evidence.
But it couldn't get you, they could still arrest you and charge you and know all these things. So it's kind of tough. It is a tough spot.
And jury's just going to have to hear it. So.
Oh, all right. We got Big Cat Operator. We get a lot of questions from him.
We like you.
Yeah. So, all right. Hey, guys, this one's for Emily. Looks like I got a job and I'm going to be traveling from Houston to Wyoming. Pulling my travel trailer up there to work in a coal mine. My question for you all, while I'm towing my travel trailer and staying in it for a few days across this beautiful country, what are my castle doctrine rights in my travel trailer? Mostly wondering about Colorado, as I always consider staying somewhere in that state, but with the guns I will be carrying, I may decide to just blow through that state and get out of there as soon as possible. Colorado has some bizarre gun laws.
It does, and I will not dare to give advice on Colorado law. In part because Colorado gun law is weird and highly specific, and in part because once I start doing that, I'm practicing law illegally outside of the state in which I am barred, and I could get in very big trouble. But I will say, yes, Colorado is going to be your problem, and as a general matter, you've got your travel trailer, you're staying in it. While it is moving, it is normally going to be treated the same way that your vehicle is. While it is stationary, there are a list of factors, but generally speaking, when you are set up for the night, if you're sleeping in it, definitely if it's like something you can hook up, you are going to be in your home in terms of how it is treated. Now, that can make a big difference in some states' castle laws. It definitely makes a big difference in terms of whether or not an officer has to get a warrant to search it. If it's a vehicle, he does not. If it is a home, a habitation, he does, unless another exception applies. So you might be less likely to be caught with guns that are illegal in Colorado. However, it's not going to be a free-for-all, everything's good just because I'm in my habitation, because once you have stopped and you are staying the night, you are ceasing traveling. So all of a sudden, your Firearm Owners Protection Act law no longer applies to you, and you are fully at the mercy of Colorado. Colorado is a big-ass state to have to hustle through, but oh boy, if you can do it, that's a very conservative advice from a Texas lawyer. I'd do it. I wouldn't risk it.
Well, and it's my understanding they don't have great statutory preemption, so big cities, Boulder, Denver, might have more strict, firearms laws. And this is just my layman understanding of how Colorado is doing this, and I know they've passed a ton of things in their last legislative session.
Richard is not licensed in Colorado either.
No, so but outside of that, I think simple answer: car treated like a car. You're using it as a habitation. Treated like a habitation.
Yeah, and if you are parked and you are staying the night and an officer asks you any questions about potential firearms or wants to search, give no consent and don't say nothing about nothing. So that's the best advice there.
Yep.
And that's nationwide advice. Okay. All right. Now we've got at Kangi13. This is about the big, beautiful bill.
Oh, okay.
So we were talking about our $0 requirement for tax for the NFA items that were potentially suppressors and short barrel firearms. And the question becomes, right? So are these, number one, now that there's a $0 tax, can they in fact remain within the NFA, which is going to be litigated, and that lawsuit has already been filed. But here is a question to that issue, which is, could you argue that you should not be able to register these firearms because Bruen does not allow it? Bruen won't allow for registration requirement. Richard, what do you think?
It's going to be an uphill battle.
Yeah.
So, we look at what's our standard under New York State Rifle and Pistol Association v. Bruen. Is this within the ambit of the Second Amendment? Mm-hmm. Yes. Okay. Well, then next step, law presumptively unconstitutional, burdens on the government to justify its existence based on the text of the Second Amendment as informed by history and tradition. Now, the big, beautiful bill revising downward the tax from $200 or $5 down to $0 for suppressors, short barrel rifles, shotguns, AOWs, does that somehow revive it to, be a fresh controversy to be litigated? I don't know. It probably does in some circumstances. So we got that. But also we look at the courts have upheld the NFA at this point. Unfortunately, it hasn't been fully litigated post New York State Rifle and Pistol Association. But I'm, and I know folks don't want to hear that answer, but I don't know that this is going to make it more of a target-rich environment.
No, here's what I believe. Not what I believe. What I believe the courts would say.
Yeah, that was kind of my perspective. Yeah. That's what the courts are going to say.
I think the courts are going to look at this because, right, we've had those laws that were challenged on the basis of, like, zoning laws, right? Like, well, there's no gun store and range here for however many miles, and that's infringing upon my Second Amendment right because I don't have access to the Second Amendment. And we've had courts be like, nope, not a Bruen issue because it's not an infringement. I could see courts saying this is not an infringement because we're not telling you can't have these items. We're not telling you that that they're inaccessible, that you're not allowed. We're just saying,
jump through the hoop.
Pick up your pen.
Peon.
Yeah, which, not my opinion,
no.
Right? I think that's absolutely ridiculous. But I do think that is what many lower courts would say. And you know what? I don't think the Supreme Court would take it up.
No.
I don't think they would.
No,
so then we'd be stuck with it.
We're dooming it a little bit. But, again, 1930.
It's my realism.
Well, you look at, hey, is this, within the ambit of what would have been regulated at the time of the adoption of the Second Amendment? I think the clear answer is no, right? Yeah. And should the infringement stand? Absolutely not. The courts, these 1930s laws, that's a big difference between 1791. The distance between those two things are very great.
I don't know. No 1791 registry.
No, but these. But you could see. I see the court sidestepping all.
They're going to sidestep because they're going to say it's not truly an infringement, and so it's not a Bruen matter. That's how they're going to get around it. We've watched them do it before, and it's gross and it's sneaky, but that's exactly what I think would happen.
Part of this is when we make predictions.
I'm wrong a lot.
Then we get wrong, so we have to pick that horse and ride it, so that hopefully the NFA is dismantled.
Right, sure
but
enough.
We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us a comment here. This is our main source of new questions for new videos. So say the word question in it. Leave us a question here. Until next time, we're the Arms Attorneys. No, sorry. There is someone kicking my guts out from the inside right now, and I got distracted for a moment because it really hurts.
Oh, I'm sorry.
She got me like I don't even know what she's
mad
right
at this discussion.
She does not like it.
The Elmo was an AI bot on Twitter, and it went off the Elmo, the Sesame Street Elmo, run by a bot, and it went off the deep end yesterday. It was pretty incredible.